Importance of the law, the importance of landmarks for New York City, especially in terms of our built environment, because this is coming from the Land Use Division. I don't think I'm going to use that. All right. So I'm just going to go straight to the outline of what we're going to cover. So as I mentioned, provenance and history. How do we have landmarks in New York City? So this is going to cover the law, the legal justification for this law, and how it's applied. We're going to go into types of landmarks. Well, we certainly think of Penn Central as a landmark. It's a place that everyone knows where it is. It's a city landmark. It's also a state and national landmark, and what all those different layers mean when we talk about landmarks in New York City. We're going to talk about landmarks and zoning. Just because you have a landmark property, what does that also mean in terms of the zoning requirements? How all these pieces fit together. We're going to have a look back at the last 50 years. The landmarks law is 50 years old as of 2015, so now we're in year 51. And we're going to look forward. What is the borough president's agenda for the next 50 years? Even though we have not a 50-year term, obviously, but we have the opportunity to impact what the landmarks law will look like for the next 50 years, and that's a chance we want to take, and we want to encourage our community boards to take. So in general, any of the stats I'm going to give tend to be more Manhattan-centric because this is the Manhattan Borough President's Office. So those of us who are joining from other community boards in other boroughs, sorry, I will not have memorized the facts for the Bronx, Brooklyn, Staten Island, or Queens, but let's just say you have a lot less than Manhattan. All right. So at the end of each section is when you should feel free to have as many questions or raise as many questions as you may have at that point, and we'll try to keep it moving that way because we do want to be cognizant of everyone's time, including mine. So we're going to try and stick to 2 hours, but again, if you have any other questions that are not covered in today's session, we have a number of other community board leadership training series, but you can also feel free to email myself or anyone else in the Land Use Division, and we will get back to you with an answer to your question. So let's dive right into provenance and history. How old is the law? I mentioned it's 51 years old, but how did we get a law in the first place? What were the movements that contributed to this idea of historic preservation? So we have to go back in time to the late 1800s to the City Beautiful movement. The City Beautiful movement was this idea of how do we make our places not just beautiful, but a place where civic engagement can happen, where people can feel like citizens, where people can feel like human beings. This is a response to the Industrial Revolution, to tenement housing, to slum conditions, to disease, to just rapid changes in how society is operating and how people are interacting with each other and with their governments. So from this movement comes this idea of if we have grand civic architecture and grand civic places for people to interact, they will interact in civil manners, in civil ways, and they will be engaged citizens. This idea of order from chaos in these grand urban spaces give us places like Penn Central, actually. So going back to this idea of like the prototypical landmark in New York City, Penn Central, this idea of a beautiful space for people to do their business and to go forth into the city. A side note about the City Beautiful movement is the City Beautiful movement was all about creating this order from chaos. That meant they didn't like small, narrow streets. They didn't like tenement housing. They didn't like things that didn't fit into a particular architecture style. So even going back to the City Beautiful movement, we have this idea of slum clearance and taking away pieces of fabric from New York City. The other contributing movement factor to our historic preservation movement for New York City is federal urban renewal policy. So this stretches from post-World War II into the 1950s. We have a lot of returning veterans. We have people who want to start families. We have to house those people. Federal urban renewal policy didn't think cities were the right place to house people. Why? We had just come back from Europe where anyone who was living in a city was more likely to get bombed, to be killed, to face a number of ravages from war. It was not a good place to store your people, your businesses, to have your economic growth in the cities. This was the mindset coming back from World War II. So what do? When they do build housing, they build it outside of the city, and if they decide to build it in the city, again, we have periods of massive slum clearance. The idea is we need modern housing. What is old will not withstand any machines of war. So that brings us to Penn Central. Penn Central was the companion piece to Grand Central. Both were owned by the Penn Central Railroad Company. At the point of, I want to say at the end of this federal housing policy, we're moving into the 60s, we've had a number of losses in New York City, especially in Manhattan, to this idea of out with the old, in with the new. Here we have Penn Central. Today, looking back at the pictures, it's a pretty obvious landmark. It was a beautiful structure designed by McKinley and White, who have given us a number of amazing buildings in Manhattan. But by the early 1960s, it was not in good shape. It hadn't been cleaned probably in 50 years. It wasn't being maintained. Railroad use had fallen into steep decline because, again, housing and businesses were moved outside of the city. So why would anyone be taking the railroad in? You have the proliferation of car use. So if any priority was going to be given to a mode of transportation, it was going to be given to private vehicles, not to mass transit. So even though we had a number of significant, again, Penn Central is not the only thing that we lost. Penn Central is one of the most visible pieces of history that we lost during this time period. And it was following the demolition of Penn Central that you really start to see broader political movement towards looking at ways to preserve our built fabric. And that's how we got the Landmarks Law. It was passed in 1965 under Mayor Wagner with the support of the Real Estate Board. And now take a moment to absorb that. The 1965 New York City Landmarks Law creates the Landmarks Preservation Commission and gives them broad authority to designate landmarks under the city system. Our law predates the National Historic Preservation Act, which is the enabling legislation for everyone else. So we led the way in landmarks. The 1966 National Historic Preservation Act is, again, the enabling legislation. So it allows local municipalities to create their own New York City Landmarks Law. It also creates something known as SHPO, or the State Historic Preservation Office. And the State Historic Preservation Office is housed under the National Park Service. And all of these, again, layers are supposed to oversee the work of preservation. So what does the Landmarks Preservation Commission do for New York City? They have the power to designate landmarks and historic districts. Landmarks, we'll get into the different types a little later on, but it's not just the outside of buildings, and that's an important piece to keep in mind. Designated landmarks can only be altered if the LPC deems those changes are appropriate. Within that frame of appropriate, that can be broken down to staff level decisions and commission level decisions. Appropriate is not a defined term. So for those of you who have taken Land Use 101 in advanced zoning, we always talk about our defined terms in the zoning resolution. Appropriateness is a subjective decision. And this is why that becomes important, that subjectivity. LPC has 11 commissioners, all appointed by the mayor, none of whom have to have a degree in historic preservation. The LPC is also responsible for commenting on all historic resources chapters in environmental impact statements. And again, we'll get into that a little bit more later. That's a really critical function of the agency in terms of making sure that the work of preservation in New York City is adhered to. So we usually like to take a little time to explain why landmarks are legal. Not everyone comes into this room saying landmarks are a wonderful thing, but we'd like to at least have you leave with, yes, they're supposed to be here. So landmarks are legal because of two pretty significant cases that went all the way to the Supreme Court. The first one involves Penn Central Railroad, also known as the Grand Central case, and that was decided in 1978. So remember, Penn Central Railroad owned both Penn Station. They went ahead and demolished that for an office building. And then we also have Grand Central Station, again owned by the Penn Central Station Railroad. So again, railroad not in high use anymore. The railroad's looking to generate funds. They have a lot of property. They need to maintain at least some of this. They have a fiduciary right or a responsibility to do something with their property that will help them maintain their business model, so to speak. So they propose for Grand Central not to tear it down, but to build a really, really, really big building on top of it. They go to the LPC. The LPC says, that is not appropriate. Sorry, we're turning down your application for a really, really tall office building on top of something that we all decided was a pretty significant individual landmark and interior landmark for the city of New York, and you should not touch this. So Penn Central Railroad is not happy with this decision and appeals to the courts. They say this is a Fifth Amendment case. They are violating my due process rights. Again, a company has due process rights. They say that this is a regulatory taking, and we'll get into what that means in a moment. And we weren't compensated for this taking. So when we talk about physical taking versus regulatory taking, this wasn't the government coming in and coming in with an army and saying, we are taking control of your property to house the militia. They're claiming that this is a regulatory taking. The rule is so restrictive that it does not allow them to exert a reasonable return on their property. And because of that, it may as well have been taken by the government for some other purpose, and the government is supposed to pay the property owner for this preservation purpose. So the courts look at this, and in probably some of my favorite language I've ever seen from a court decision, they say, no, historic preservation is a public purpose, that the building fabric is important for citizens. And again, remember City Beautiful movement, some of those things were a good thing. We want our citizens to feel engaged. We want our buildings, our civic structures to remain. So the irony of the City Beautiful movement is that they gave us these buildings, but they also destroyed a lot. And it is only 50 years later that they are then themselves under demolition. So here we are. Supreme Court says it's a historic preservation as a public purpose, and they say the property owner does have the opportunity for just compensation because they are allowed to transfer their development rights. And we'll talk about that a bit more when we get to the zoning section. But the landmarks law does not say you can't use your building. It doesn't say you can't develop your property. It just says you can't do whatever you want with your property and that there are limits to what you can do. But the landmarks law and historic preservation is well within those limits of the what we refer to as the police power. Is city government or government in general acting in the general welfare and the public health and safety purposes of its citizenry? And the Supreme Court resoundingly said yes. The next case is St. Bartholomew's Church. This case was decided in 1990. This was a First Amendment case. They said, oh, our freedom for religion is being violated with the landmarks law. They too wanted to build an office tower. It seemed to be the mode of choice for commercial development was the way to get money. They said the application of the law is arbitrary and capricious. They said we're being singled out as religious structures. It's not our fault our buildings are beautiful. Please don't designate us. The court also decided that this was not a valid argument. Again, historic preservation is very firmly a public purpose. The law does not say you cannot operate as a church. It does not say you cannot operate as a synagogue. It does not say you cannot operate as any other religion you would like to claim under these walls. All it says is that you cannot do, again, whatever you feel like to that building. So this church now remains as a significant individual landmark, and it really goes to this idea of separation between church and state, and it says it doesn't matter who you are, preservation is a public purpose, and the law is applied equally to private individuals, to large property owners, to religious institutions. What the law is about is your building significant to the development of New York City? So that brings us to the end of how do we have a landmarks law, and we'll open it up for a few questions.
So I'm just trying to understand this. So 100 years ago, if I owned a piece of land and I leased it to a church and they built this beautiful structure on it, I basically, I hate to use this term, but I basically am screwed by the law for allowing that to occur, right?
No. All right, I'll go back to my opening statement. Preservation is a priority for President Brewer, so we would not say you're screwed. There's a lot of regulations within New York City that limit how you can use your property. The landmarks law is just one example. But the landmarks law does not apply to every property. So a little later on, we're going to talk about how does a building become a landmark. Just because you have a church on a property doesn't automatically mean it's a landmark, even though for most walking by, if it's a church built in sometime between 1900 and 1910, I'm sure it's gorgeous and probably meets a number of the eligibility criteria. But it's not necessarily a landmark.
Okay, I'm sorry, that wasn't really my question. But my question is, nowadays, are people being very careful on what they build on properties. There's a lot of building going on in the city to maximize what the future value may be so that they don't lose their rights to, like, if I owned a piece of land now, I would never build a church on that land, or
Well, most
whatever.
likely a church wouldn't choose to build a 100% stone structure with stained glass windows because, as we have found out, that's rather expensive to maintain given dwindling church, or religious, I should say, religious organizations, dwindling congregations in general. That's just the modern trend. It's much harder to maintain those types of structures. You don't see religious institutions necessarily building something like that. One never knows what will be a landmark. When the Empire State Building, an individual landmark, was constructed, pretty much universally every single paper said it was the ugliest building they've ever seen. From every architecture critic was like, this is awful, what were they thinking, this is hideous, we should tear it down immediately. They tore down a building that had been there for, I want to say, over 80 years. That should have been designated as a landmark. They didn't have a landmark law then, but this is the type of discussion that happens over and over and over again. We don't know what will be a landmark in 100 years, or 50 years, or 30 years. It is a subjective analysis, except for the fact the landmarks law has a number of set criteria. Now, you can be a property owner and say, I'm not going to build anything because there's no way they're going to designate my empty lot. That may be a 100% way to ensure your development rights in the future, but as Staten Island has found, this will be my one Staten Island reference, even those open lots have pretty significant development history because of the farming and archaeological remains below. So there are no guarantees in life. There's certainly no guarantees in New York City real estate, and best wishes. Yes.
You have an abbreviation here, EIS, responsible for commenting on all historic resources.
Yes.
What's EIS?
EIS stands for Environmental Impact Statement.
Oh, okay.
So if you haven't yet, you can take Land Use 101. If you've already taken Land Use 101 and need a refresher, we'll be covering EIS as an environmental review in a little bit when we do advanced zoning at the end of June. So feel free to sign up for that one. So it's just part of the environmental review process. It's, again, designated by the city through enabling legislation from the state.
And for alterations on landmark buildings, so the LPC, are there any conditions of the appropriateness for LPC, or
Yes.
they have free reign?
They have a general framework and buckets under which they can make the decisions. And we'll get into that a little bit more in a bit in terms of when we talk about the different types of landmarks, and specifically New York City landmarks. There's different permitting processes, and those are all governed underneath the New York City Charter under Title 63, I believe it is. And it has, again, a general framework for what's determined, but it's up to staff to say, okay, this rises to this level of public review or this level of a ministerial action. Okay. Any other questions on how we have a landmarks law? So we'll dive right into types of landmarks. So we'll start with my favorite, New York City landmarks, because we're in New York City. So a landmark is a building, property, or object. People forget about the object. That has been designated by the LPC because it has a special character or a special historical or aesthetic interest or value as part of the development, heritage, or cultural characteristics of the city, state, or nation. What does all that mean? Right. Special character can refer to not just its built fabric, but what does it signify at that moment of time? So going back to the Empire State Building, all the architectural critics hated it. They thought it was unoriginal. They were coming from this idea of, they loved, I'm going to say, all the Baroque detailing, and here is this modern steel thing rising up. It killed all these people to build. Like, what are we doing? It is a very unique building. It has special character. Special historical or aesthetic interest. So this is, when we talk about aesthetics, again, it can be subjective, but when we talk about aesthetics, we're usually referring to architectural style. There are distinct periods of architectural style when you look at the history of architecture. So you look at certain buildings and you're like, oh, okay, that is very clearly Romanesque, or that is very clearly Gothic revival, or that is some combination of the aforementioned, and it shows a period of development for that particular religious institution. Historical value is much more spongy. It can mean the people who were there, who worship there. It can mean the people who work there, the people who live there. But it can't be a fly-by-the-night, oh, someone slept here thing. Unless that someone who slept there gave their inauguration speech the next morning, as is the case for Francis Tavern. Something's really important in the history of our city or our state needed to have happened at that location. It's not just oh, I think this is important because it's important to me. And then we talk about value as part of the development, heritage, or cultural characteristics of the city, state, or nation. Again, this isn't like a strict legal definition. That's why it's up to the experts, so to speak, of the Landmarks Preservation Commission and their staff to say, does it meet these criteria? But over time, this has been clearly meant to mean something that looks of a certain time period, is a clear architectural style, instituted a very unique engineering capability, going back to the Empire State Building in terms of how they were able to build that structure. That was very unique, use of steel. It was the first time they were doing something like this. They were in a race with the Chrysler Building. Who won? They're both individual landmarks. So, and then cultural characteristics. Over time, that has not been something the LPC has traditionally exercised. How do you determine something is important from a cultural basis? That is probably out of the historical or aesthetic interest pieces the most subjective, because it really depends on who is sitting on the commission. Now, historically, if it's, and no offense to those of you who fit this category, if it's white men of a certain age, they're not necessarily interested in where the suffragettes were meeting, or interested in the Triangle Shirtwaist Factory site, or interested in where the Girl Scouts met, or interested in anything other than what fit their model. Now, times have changed, cultural definitions have changed, and one of the things that the borough president always advocates for is we need to expand our cultural definition as well to be inclusive of all the people, whether it's race, color, ethnicity, religion, life experiences that have made the city as rich as it has. So when we talk about New York City landmarks, that means anything that has actually been designated by the commission. So Madison Square Garden is a landmark in the transportation sense. You say, meet me at Madison Square Garden, everyone knows where that is. It is not a landmark. Grand Central is a New York City designated landmark. So types of New York City landmarks, we have 4 types. We have individual landmarks, interior landmarks, scenic landmarks, and historic districts. To be an individual landmark, you must be at least 30 years old. That's your floor, of your age floor, to be an individual landmark. So Manhattan, and I want to make sure I get my statistics right here. Numbers are not always my strong suit. Manhattan has 879 individual landmarks. We have 65% of the city's landmarks. So again, you have to be 30 years old. You have to have cultural, historic, or aesthetic significance. Those are the 2 main criteria for being an individual landmark. An interior landmark must also be at least 30 years old, have historic, cultural, or aesthetic significance, and must be a place that is customarily accessible by the public. So LPC cannot designate some wealthy family's library room, no matter how beautiful the furnishings are. But that is why religious institutions that were built, say, anywhere from 60 to 100 years ago, are customarily open to the public, certainly had significant value into their design, tend to be interior landmarks. Other interior landmarks would be the public library, and then one of the backlog items actually on right now, and we'll get to what the backlog is a little later, is in the UN, some of the surrounding buildings. There were a number of meeting spaces that historically were open to the public that were designed by significant architects in the 60s and 70s. So this is part of the debate. What is an interior landmark? What is actually customarily accessible to the public? Scenic landmarks. There are only 10 in all of the 5 boroughs. 6 of them are in Manhattan. So Fort Tryon Park, Grand Central. When we think about a scenic landmark, it is something beautiful and expansive and that was designed with purpose. So it's not necessarily just an open wooded area. It has to have that, that design intent there. There is no age requirement for scenic landmarks because it's very feasible for a number of the plants to be less than 30 years old. But the design itself had to have been considered at some point prior to that. Historic districts also do not have an age requirement, but they must represent a significant and consistent streetscape and period of development for that neighborhood. So some of our best examples of our historic districts are the Soho Cast Iron Historic District. It was one of the first districts, not the first, but one of the first districts designated under the LPC when it was formed in 1965. It is the largest collection of cast iron buildings in the world. It is also pretty homogeneously developed within a set period of time. So when we talk about historic districts, we have 77, including extensions within Manhattan. It's about finding that collective history and making sure that that collection of buildings represents that collective history. So a number of historic districts have been extended over time as more research is done, but also because the periods of development have shifted. The LPC historically was only interested in looking at districts only developed in the mid-1800s. That was a very clear, oh, we know City Beautiful movement, we know what that architecture is like. It's classical architecture, we recognize it, we're all trained from a certain architectural viewpoint. Those are obvious landmarks, we're going to designate those. Over time, we've designated a number of other types of historic districts. There's commercial districts, there's residential historic districts, and it's been more expansive. We wanted to capture residential development. So you look at Mount Morris Park, you look at Bedford-Stuyvesant, and you look at these other historic districts, and it's not necessarily it's not Soho. And the fact that they're not Soho is also what makes them unique and special and worthy of designation because it represents different periods of development within New York City. I'm going to take a momentary break because I know that's a lot to absorb just on the city landmark side before we get into state and national. Are there any questions on city landmarks?
Can you fit into both categories? If you're a building within a district, are you automatically like...
An individual?
Well, I guess you would be, right?
No. No. To be an individual landmark is a higher bar of consideration. The individual building must meet all those criteria versus as a historic district, you can have a collection of buildings that some of them individually may not even be 30 years old. Some of them individually may be a gas station. But it's part of the history of development of that particular neighborhood, so it is still worthy of being part of the historic district, but in and of itself would not rise to that level.
I'm curious about the notion of the interior of a religious structure being designated as an interior landmark. Recent times when the Commission has heard these things, for example, in clearing the backlog, there are a lot of houses of worship that were among the 95 that the borough president said should not just be swept aside. The point was made repeatedly by the commissioners that the interior, don't worry, the interior won't be designated because of the religious iconography and the idea that if a different sect were to take over the structure and didn't care for the decorations of the previous tenant, as it were, that would be a First Amendment free exercise problem. How does that find itself working out?
Well, even though the LPC has the ability to designate objects, it does not designate objects. It won't designate the altar. It won't designate the subject matter of the stained glass window, but they can still say a stained glass window is a significant part or the fabric of that historic building. And that's one thing we've always been very careful about when we give comments on religious institutions changing over into, I want to say private use, is we've always say, look, the designation report says the stained glass window is what made this a church, it's what made this a synagogue. But someone probably doesn't want that particular imagery hanging over their dining room table. But the fact that it's stained glass is what's important to remain. So going back to this question of how do you decide on the interior, for a number of these churches that do have interior designations, and again, talking about like some of the earlier examples that the LPC designated, it's spaces that were designed with clear intent to be used by the general public. They were spaces designed with clear intent that work in conjunction with the outside of these buildings. There are actually not a huge number of interior landmarks, and there's certainly not a huge number of religious interior landmarks because of this balance you have to strike. But if the altarpiece was designed by a significant architect and is the only one of its kind in the city, whoever's coming in next will need to respect that. They don't have to use it as an altar. And that goes back to, oh, am I impeding on someone's religion? There's nothing in the designation reports for these interior spaces for religious institutions saying you must use this in the same way. It just says you can't take it out. And that's the fine difference.
What's the origin of these 4 different types of New York City landmarks? Like when were they classified?
So the first ones were the individual and the historic districts. Those date back to 1965. After the National Historic Preservation Act was passed, again, it came after, but it was in some ways more expansive. These other types were added. And this is also as the preservation movement grows. Again, originally they were very concerned with preserving these grand civic buildings and these grand civic areas that have been created, whether it was downtown or in Midtown or throughout the city. Is this idea of Grand Army Plaza? Oh, we created this as an area. We need to preserve it as an area. It was only later on that attention was starting to be turned to what's happening on the inside of these spaces. People were coming in, again, taking the religious institutions as an example. Religious institutions were leaving, someone else was coming in. All of a sudden, spaces that people had come to rely on in their minds and as part of their neighborhood fabric as always being there, weren't going to be there, and they were under threat. So again, this was added to the landmarks law as a way to preserve those significant spaces. Okay, you also have your...
Yeah, I'm just sort of curious about the hierarchy of individual versus historic district. Back to his original question, which is, you have a historic district and you have a protected district. Is it necessary to then go out and try to get something individually landmarked for additional protection, or is there a...
Oh, yeah, I mean, absolutely, because it's a different layer or layer of review and layer of significance that an individual landmark must have. It also means that you can have individual landmarks within historic districts, and you can have individual landmarks independent of historic districts, and we have that throughout the city. So they're not exclusive of each other.
Yeah, I'm not completely clear on what is protected in the historic district.
So the district is protected, and a little bit we'll get, I want to say about next section. We'll get into what does it mean in terms of what do I have to do? I have a property in a historic district. What rules do I have to follow? But it doesn't. There's different layers and different layers of protection, but also different layers of review when you look at whether it's an individual landmark or a historic district.
You had mentioned that Fort Tryon Park is a scenic district, and I'm just curious, is it the whole park, the cloisters, the fort, or what?
The cloisters and the fort are individual landmarks within a broader scenic landmark. So again, remember you can, based on the level of significance, it can rise to different levels of designation. So in terms of Fort Tryon Park, in terms of the scenic landmark, it's the grass, right, and the trees and those view sheds.
Something that is a historically significant space. I'm thinking of a lot of cities that mark off the space where maybe slaves were sold historically. Does that fall into any of these categories?
So,
with no collection of buildings on it whatsoever.
Right, so traditionally, no, not for New York City. So if it's all right with everyone, I'll start going into state and national landmarks, and that's what that example would actually fall most clearly under. So state and national landmarks, what does that mean? So this is not something approved by the New York City Landmarks Preservation Commission. These are items that appear on the state and national register of historic places. They have to be 50 years or older, so not the 30 years under local law, and significant for historical, cultural, architectural, archaeological, or technological reasons. So under state and national register, you can have things like a bridge, Even though New York City has an individual landmark, Brooklyn Bridge, traditionally in other municipalities, their local laws don't cover things like bridges or former slave grounds or former commerce areas for shipping. The state, again, going back to the National Historic Preservation Act, that act for the states covers that broader sense of what is a landmark. The listing requires owner permission. New York City Landmarks Law does not. This does. State and National Register of Historic Places, even once someone is on that, does not preclude demolition, for better or for worse. It does require review by the State Historic Preservation Office if you are going to move forward with demolition. And the number one requirement SHPO will have is you must document everything. And again, this goes back to this idea, the state and national landmarks aren't just the tangible, it's what has happened in the past and how do we preserve that for the future. So that it's a clear distinction between the New York City Landmarks Law, which says, no, it has to physically be here.
Excuse me, can you just repeat that in a state national landmark district, if someone is going to demolish something, it needs to be documented, and although they can't prevent demolition, there needs to be.
Correct.
And what does that documentation entail?
Documentation includes surveying, extensive photographic records. Like I'm talking about as you pull apart the wood joist for say a historic farmhouse in Idaho, you must document, you must measure out the number of those joists, and it's clearly if someone wants to recreate that building or put it back together, that they will be able to do so. So again, this is independent of whatever the local laws are. In New York City, you cannot just go ahead and demolish your historic building, even if it's not in a historic district. You still need to get permission to demolish something from the Department of Buildings. If you are on a city historic district that's also on a state and national district, then you have two levels of review. You have to go to LPC and you have to go to the State Historic Preservation Office. Now, what do you get if you are on a state and national landmark list? You get a 20% tax credit toward any of your rehabilitation work. That is not insignificant. National Parks has overseen $69 billion in tax credits across the country. Manhattan has 500 listings on the State and National Register of Historic Places. Now, I've been using state and national pretty interchangeably. Once someone is listed on the state register, that application is forwarded to the National Trust. They review it, and pretty much 99% of the time they sign off and say yes, because it is significant at the state level, it is important on the national level, and it ends up on the National Register. So you are then eligible for state and federal tax credits for that work.
Are there any city tax credits?
No.
that exist? Oh.
And if something is already a New York City landmark, is it an arduous process to become a state or national?
No. Once something is a city landmark, you already have a designation report from the LPC saying why it is significant. That makes it very easy to populate the forms available from the State Historic Preservation Office saying, please describe why this building is significant. What is different from the LPC process for becoming a landmark, which we'll get into in a little bit, versus the state process. The state and national process require a significant amount of documentation up front from the person making the application. So this includes a statement of significance, photographic evidence, whatever deed research someone may have done to say this is who owned it, this is who lives there, and again requires the owner permission.
Who can request for a property to be landmarked? Because given all of the criteria and all of the restrictions for New York City landmarks, for instance, Lenox Lounge in Harlem, they just basically dismantled it, and I keep saying, why wasn't that made a landmark? And can somebody from the outside ask, or does it have to be the owner, or how does that?
For the city process, no, and we'll get into that in just a little bit. So hopefully I'll be able to answer all your questions on there. So I'm going to move on from city, state, and national to eligible historic resources. There's a whole other bucket of landmarks when we talk about landmarks for the city. Eligible historic resources are anything that is already designated a New York City landmark, anything that is already on the State and National Register of Historic Places, and anything that meets the eligibility criteria but has not yet been designated. That last piece is significantly important when you talk about environmental review on the city and state and federal level. So again, that environmental review. Environmental review is disclosure process, and that disclosure process must disclose whether there's going to be any impacts, good or bad, to eligible historic resources. So there's been a number of times when you've had, I want to say, whatever type of building you can think of within a development site radius, and it's not necessarily considered because, oh, it's not a landmark yet. But if that building is significant to that neighborhood, again, in terms of development history, in terms of its architecture, in terms of its cultural significance, then under the statutes for the city and state, it must be analyzed. Will there be light and shadow impacts if there's stained glass windows? If there's a planned open space that is customarily open to the public and dates back to 1923 and was designed by a significant landscape architect, what is the impact of light and shadow to that space? These are the types of things that it's very important for the local community board and the members to identify, because you have an outside person coming in doing this environmental review. They don't know that that building around the corner is significant for any of those reasons, but you do. Then you have Section 106 review. Section 106 review falls under the National Historic Preservation Act and says if any project is receiving federal funds, looking at you, DOT, you must determine whether there's any eligible historic resources within your work area, your area of your scope. You must talk to those property owners. That's important. You must talk to them. Can't ignore them. You have to talk to them. And you must work to mitigate any impact. It's one of the strongest pieces of environmental review statute you'll see in this country when it comes to landmark preservation. You have to talk to people. Since when does government say you have to talk to people? This says you have to talk to them if you want to get any of those federal funds. All right, so now we're going to move into landmarks and zoning, how all these different regulations work. So I'll just take a moment to answer any questions on the eligible historic resources piece and any outstanding questions in state and national. Yes?
So can you just describe how this all occurs? So, for example, I own a little brownstone. I want to demolish it. It's not on the landmark. I file my permits quietly, and then like the whole thing blows up, basically, right?
Welcome to New York City.
Like, how does this all roll out in a normal?
So we've had a few questions on process. How does someone get designated? Can I nominate something? When we get to the last 50 years, we'll go through step by step the process for designation.
I just want to say congratulations because I have to run to precinct council meetings. I'd much rather be here. But I want to just congratulate everyone for participating. Basha Gephardt is amazing, and Deputy Borough President Aldrin Bonilla, you don't have better, but the fact that you're putting all this time in, we are deeply appreciative. And I could learn a lot more than I could at any other meeting, so thank you for being here. Thank you all for your service, whatever you're doing. Wow, it's nice to see you. So, congratulations. Thank you.
So,
Could you just go back to the immediately preceding slide? You said the definition includes that something must be already designated. And I completely missed what I was defining. What's the point of this slide?
So the term eligible historic resources is a term you'll see in these environmental review statutes, and say you have to analyze impacts to eligible historic resources. So that phrase up there, that refers to anything that is already designated by the city. So for New York City, it's anything designated by the LPC already. Eligible historic resources also includes anything on the state and national register of historic places that is uniform throughout the country. And then it includes anything that meets the criteria for the state or national register or the local municipality. And again, this is all coming from the state enabling legislation, National Historic Preservation Act.
So, for instance, that meets the criteria, does that mean that they have to go look and see, as if they were going to try to designate something?
Yes,
Okay.
yes, it's all about due diligence and disclosure.
For Section 106 review, so this, you mentioned it requires people to talk to people. What does that mean? Does it mean like a letter of support from the community, or?
No, it's an opportunity for dialogue. It's not necessarily an opportunity for agreement or an opportunity for sign off. One of the requirements that was mitigation measures. So if DOT, because DOT is usually who has to do this because they're, especially on the city or state level, they're always receiving some type of federal funds. They're building a new highway ramp, and that highway ramp is going to crisscross over a section of a historic cemetery. Obviously, the residents of that particular space cannot speak for themselves, but they have to speak to the local property owners and to the management of the cemetery. So they say, look, we have to build this highway ramp, we have all the federal funds in place, it's the only way, the other one's crumbling, we don't want anyone to die, we have to do this. There's a significant public need. Have to do this by demolishing the gravestones is very different than have to do this, how can we cantilever over these historic stones, what measures can we put in place during construction to minimize vibrations so we don't disturb, again, the fragile stones. Do you want us to put additional planting on the side of where the ramp is? So when we talk about mitigation measures, that's some of the examples, and again, it's about having that discussion. They're going to build that highway ramp, but again, they have to talk to you about it first. Yes?
Let's say for the sake of argument, I own a building that is an individual New York City landmark, and I decide it's too onerous for me to pay whatever is involved, and I just abandon the property. Then what happens?
Up until, I'm going to say, up until maybe 8 or 10 years ago, and I'm a little fuzzy on the exact adoption date, you could do that. And the building could fall apart, and it was referred to as demolition by neglect. DOB would come in and say, we have to put a vacate order, it's no longer structurally sound, the building's going to get torn down. Unfortunately, there were a number of property owners who engaged in this practice and took advantage of a loophole in the landmarks law. That loophole was closed. The city can come in and take the property, stabilize it. Again, they're not going to fix it to pristine Class A condition, but they can stabilize the property so that it will not need to be demolished because of structural insufficiencies. And they will then charge that work to the property owner. Again, preservation is a public purpose. You as a property owner have a responsibility to fulfill that part of the public purpose as a privilege of owning property in New York City.
I just had a quick question about the state and national landmark. So if you're in a historical district and that makes you eligible for rehab work, 20% rehab work on a state and local level?
State and national level.
And national level?
Yes.
Even if it's a privately owned home?
Even if it's a privately owned home. But again, it has to be you have to be a property owner within the state or national, and state and national boundaries don't always correspond with cities. So you could be in a city district and not be eligible for those tax credits because there's no overlap there. Because there are no tax credits on the city level. Yes.
Are there any tax abatements on the city level?
No. There are
benefits.
grant programs, different funding programs through some of the advocacy groups in New York City, specifically for religious institutions, for small business owners, for certain districts have their own, I want to say, mechanisms in place to generate funds to help with rehab work. But this is pretty consistent across the nation. The money's only coming from the state and national level for those tax credits. Yes.
So I understand that state and national developers can demolish and develop as of right. But I'm confused. Does the developer need to consult with the community and at least have a dialogue? Or is that only if they're asking for federal funding?
If you're asking for federal funding as a city, I want to say any agency, whether city, state, or federal agency, you must consult. If you're a private developer receiving federal funds, you must consult. If you are a private developer not receiving federal funds in only a state or national district, again, not in a city district, you are required to go through SHPO review. State Historic Preservation Office, one of their questions, one of their checkboxes is going to be, have you talked to your community? Because again, they're the local experts, they will know what else you need to document.
So how do you enforce that? Because I'm in a state and national district, the developers are just decimating or trying to...
You guys, land use division's 7 people, right? The borough president's office is, what are we up to, Aldrin, 48?
Well, I'm happy to do it.
No, but
how do we do it? How do we do it?
Right, so how do you do it? You tell
Because
us.
we don't even know that.
No, but that's why we have
Okay.
these trainings, right? We want to give you the tools because you're our eyes on the ground. Preservation is
Okay.
incredibly important, but we can't be on every block in every neighborhood. If you see something that doesn't seem right, State Historic Preservation Office doesn't have officers on the ground or park rangers on the ground either. The only way we're going to hear about these is from our community boards and from our community members. So what do? You see someone's demolishing a building, you're in a state or national historic district. You think that was a building that was listed in the register, for merit as contributing to that district. You call us. We do the research, we call SHPO, we say, hey, has anyone from this property come to talk to you? No? Okay. And then we start the wheels rolling. But we can't do those calls, we can't do that research if we don't know if a building is at risk. There's also advocacy groups that have a lot of brain power to work on these issues. But again, they're not everywhere, and some of them have better relationships with certain communities than others just because of historically how their boards have been made up and who has worked with those agencies. But they have told us over and over again, anyone who calls will take the call. So we are happy to direct folks to them as well.
How do we get your phone number?
You'll have my email at the bottom. It's actually
Okay, great.
the best way to get a hold of me. Yes.
So you said in the national historic, national and state, it doesn't preclude demolition.
Correct.
Are there any circumstances in which they can say you cannot demolish that?
Yes. Yes, they can. If you own an underground railroad building, do not even bother asking State Historic Preservation Office because there's only so few of those. You need to have a good reason for why you need to demolish a building. It can't be, I'm sick of taking care of it. It can't be, I'm not into this architectural style. You bought the building. You bought the building knowing it was on the register. If you were designated while you own the building, you signed off on that designation for the state and national register. So it has to be a really good reason. And financial is not it. Aesthetics is not it. There was a hurricane. There was a fire. The building has started to crumble because of fire ants. Something beyond your control, something beyond finances has to happen for them to sign off on that. And again, they're going to tell you you need to document everything.
Are there any protections for projects that are pending LPC review?
Yes, we'll get into that a little bit as we move to the next section. So are we ready to move on? Okay.
So if you own a landmark, you can sell it?
Yes.
And
please tell the next person they're buying a landmark.
right. You can sell it to anybody.
Yes, absolutely.
Okay.
There's no restrictions on ownership or sale price. There's a lot of debate whether preservation helps or hurts individual property owners. I think they have found over time, not just in New York City, it stabilizes property values within historic districts, tends to raise property values within those districts, so certainly feel free to sell. Yes.
Does the community board page on the web has the landmarks listed for that community, or we have like a larger source of information? How do you check that a place or area or whatever we're looking at is under which category?
So each community board should have a hard copy of all of the designation reports for their district. So whether it was individual landmarks, historic districts, scenics, they're supposed to have those hard copies. All the designation reports are available online through the Neighborhood Preservation Center, and now, relatively recently, through the LPC website itself. The LPC website also has a little tracker. You can enter in your address, and it'll tell you whether you're in a district or a landmark or not. These are all very recent additions to the utility of the LPC website, and that's thanks to Chair Srinivasan. Previously, the designation reports were not on the LPC website unless they were done in the last 5 years. Neighborhood Preservation Center is the one going back to 1965. You still can't search for everything on the LPC site, so not all the permits, historical, I would say permits for like an addition or window changes, those are not available on the LPC website. There's a number of things that are not available yet. And when we start our look back, we're going to start digging into how many things are not clear.
Forgive my ignorance, but what is a neighborhood preservation center?
It's just a website. It's
okay.
literally one of these resources for those interested in preservation.
Can a developer come into a community that has, is surrounded by landmarks, construct a very futuristic or maybe modern development, and I know it affects the neighborhood, but does it have a say, the preservation?
Right, so as part of, 2 seconds.
Yes,
We'll get
yes.
into. But the LPC, if it's a certificate of appropriateness, which is what an infill building like that would be in a historic district, there is a public hearing as part of that process. The community can certainly attend and should attend and voice their opinions on such a design. The LPC at the end of the day is going to decide, is it appropriate? One of the central, I want to say, push and pull arguments within historic preservation is how much do you preserve and how much room do you leave for future landmarks?
Okay.
Going back to that Empire State Building example, everyone hated it. They hated it.
So
what would we do if it wasn't part of our skyline today?
Would we ever see a futuristic city? Like, I'm looking down, I'm not gonna be here in this body, but my spirit will be here.
You can go right now into Ladies Mile Historic District and see some of those futuristic buildings. You can go look in some of the things that are going up in Greenwich Village. You can look at some of the infill in Soho. Throughout our historic districts, there's been these infill buildings that don't look like the neighborhood around it.
Okay.
They're infill for a reason, and they were subject to a public review process for a reason.
All right.
So it's already after 7.
So it's gonna be
and
unique,
we're
New
not
York, like
halfway through, so I would like us to move forward.
Wow.
All right, landmarks and zoning. How do all these pieces fit together? So just because you're in historic district doesn't mean nothing else applies. Zoning still applies in historic districts. So now you have 2 regulatory powers looking over you. So you have what's in the zoning resolution, saying what you can build in terms of height and form and density and use. And then you have the LPC requirements dictating how much you can build within that zoning envelope and whether those additions or changes are going to be appropriate to either the individual landmark or the historic district. So again, you have these 2 pieces working together. They're not always seamless. A good example of this is you can have a historic district where, say, most of the district has a height of about 65 feet. Everything's pretty homogeneous, but the zoning for that district actually allows buildings of 100 or more. So there is a lot of mismatch in the borough of Manhattan between the zoning framework, what you can build as of right, and what the actual character of that historic district can be. What it does allow for is once you are a New York City designated landmark, so again, not state or national, you have to be designated a New York City landmark, it allows you to be eligible for special permits and the transfer of development rights. So these are special permits unique to individual landmarks in historic districts. And part of that argument, going back to the Penn Central case over Grand Central, part of what made the rule not a regulatory taking, because you do have flexibility. So we're going to go through this section and then break for questions. So again, with the special permits, only city landmarks are eligible. So it doesn't matter if you're on the state or national. If you're not a city landmark, you cannot apply for these special permits. You are still required to go to LPC for certificate of appropriateness or whatever permits they require you to do. You still have to go to the Department of Buildings. But you can get zoning relief available through these 3 special permits. They're known as the 74711, 74712, and 7479. 74711 has been used over 200 times throughout the city. Half of that, pretty much in Community Board 2, most of those within Soho. Very popular special permit for zoning relief. It has 2 pieces. It allows for flexibility in use or flexibility in building height and setback. It does not affect floor area ratio. It does not allow you to build denser. It just allows you to build higher or to do a different use. You can only use that special permit if you're an individual landmark or in a historic district. 74712 is specifically written for properties within historic districts that have vacant parcels or underbuilt property within its particular zoning lot. So for those of you who have not taken Land Use 101, the zoning lot is the basis under which all zoning is calculated upon, whether it's floor area, height and setback rules, it's all based on that unit of measurement. Landmarks doesn't consider how big the zoning lot is. They just say this is the significant structure. They don't always designate the entire zoning lot. Or sometimes you can have, in a historic district, you can have one building that is contributing to the district. It has a very distinct architectural style. It's part of the development of that neighborhood. And next to it could be the gas station. Gas station is part of the historic district, but it is not something that contributes to its character. That is an infill site. So if you have that combination, that those two pieces are actually on the same zoning lot, then you can do the 74-712. And that allows for infill, and again, allows for flexibility for height and setback rules, and yards and courts, what we refer to as the bulk requirements. It does not allow for flexibility in use traditionally. At this point, this special permit is not as well utilized as 74-711. It's still been used, I want to say, approximately 40 some odd times. And at this point, there's really only 3 or 4 available sites left because of the way the rules have changed over time. And again, all of those sites are in CB2. 74-79 allows for the transfer development rights. So going back to Grand Central, it allows Grand Central to transfer development rights, not just next to it, but across the street in all angles. So it gives it a broader radius to transfer its development rights. This special permit has only been used a dozen times. Not so many places for development rights to land in the borough of Manhattan when you have already a significant number of individual landmarks or historic districts. And again, it really depends on the zoning. The plus for a developer or someone choosing to go through a ULURP process for the 74-79, the 74-79 allows a blank slate for where the development rights are landing. So going back to the church example, you have an active congregation, they love their building, they respect their building, they're going to maintain their building. They want to make sure they have the money to do that. They have all these development rights. They're in Midtown. They have a high-density residential or commercial district equivalent. Their development rights are valuable. But it's still zoning. You still have limits on how big you can go, how high, how wide, how deep. You still have yard requirements. This special permit allows you to waive all of those things because of the greater public good, preservation. So that's how landmarks and zoning work together. So how do transfer development rights work? Yeah. That always is, you can almost see the questions start forming over folks' heads. So again, it's a special permit. You also have some sub-districts specifically written for these pieces. So sometimes it's done by certification or authorization, depending on the I want to say the mechanisms or the mechanics of a particular district. But in general, 74-79 is your option. So what does it mean? You have the unused development rights over a landmark. So again, the zoning resolution allows to say, oh, you can go up to 200 feet, you have extra floor area. After Grand Central and St. Bart's, no one really has any interest in trying to build a commercial tower over their stained glass windows. That is seen as probably not an appropriate thing. So they have extra development rights. So it allows them, again, to put those development rights on another building. So it's literally moving volume. Please do not say air rights. We go into this in great detail, land use 101 and advanced zoning, but I will say it here as well. It's development rights, it's floor area, it's FAR, it's not air rights, it's not FAR. If you have that, if you take that away from this class and appreciation for our law, I feel like I will have done my job tonight, so please. And then I also mentioned the specially down district theater sub-district. What does all that mean? Within the theater sub-district, again, they want to preserve the theaters, but they didn't necessarily designate all the theaters as individual landmarks. Why? That would make it really hard every time you had a new show to change your scenery. Every time you wanted to do a different type of performance or use a different size band or orchestra, it would be really hard if all these theaters, which are customarily open to the public and were designed with intent and a certain aesthetic purpose, to be tied to a strict permitting process. And the theater district is incredibly important to the economy of Manhattan and the city. So we have the sub-district. It says you can transfer, just like this, development rights from any of these theaters within a corridor. Within that quarter, you can transfer these development rights, and a portion of the sale price will go to the Theater District Council. The Theater District Council can then use their cut of the development right transfer to fund programs that will enhance and improve and maintain the vitality of the theater district. So that's how landmarks and zoning work. In the next section, we're finally going to, I know you've all been very patient, we're finally going to get to how does something become a landmark? And it's a process that has built up over the last 50 years. So before I move on, though, I just want to make sure if there's any questions on the zoning piece with how landmarks are.
With the TDR,
Yes.
that means then like, let's say traditionally on the other building where you're transferring to, let's say there was a height limit of, let's say, 100 feet.
Mm-hmm.
That means that you can still add on top of that because you're transferring over?
If you're going through the 7479 process, yes. But that's a special permit, it goes through ULIP, there's community board review, the borough president reviews it, it goes to the city planning commission, then the city council has the option to take up the item.
So in one example that we've had on the Upper East Side is that you have an R8B district where you have a required 30-foot that rear yard, and there are historic districts where the brownstones have like a 35 or 40-foot rear yard. And if someone wants to come in and extend the back of their building to the legal limit, but it would no longer kind of conform to the line of the buildings in that historic district, can the LPC say, no, that's not appropriate, even though you're legally allowed to do that?
Yes, of course, they can say no. Will they is up to you, is questionable. Again, going back to, right, it's subjective, what is appropriate? Are there other buildings within that block that are already infilled up to a certain point? It's a much harder bar to meet when we start talking about these interior courtyards and these insides of these blocks when there's a history or a pattern of infill over time. Now, if you have a completely homogeneous donut, we refer to it as the historic donut, it's a much harder bar for someone to reach when they're saying, oh, I want to do this infill. Yes?
The zoning would be available through 74-711.
Yes.
I understand the other two, like that one, just can you explain it one more time?
Yes, so 74-711 is one of the more common zoning relief that a landmark property owner will seek. So in a number of districts, there's rules on the ground floor. So we always go back to Soho because it's used the most of them, but Ladies Mile has similar requirements because it's former manufacturing. The manufacturing zoning does not allow retail use on the ground floor. So if someone wishes to put retail use on the ground floor, that does not conform with zoning, or I should say comply with zoning, uses do not comply, and they have to seek relief through that special permit. If they were not a landmark property and they were in a M15B district, they would not be allowed to do that. There would be no relief from that requirement. But as a landmark property, there's relief. Because again, the preservation purpose is held above those particular zoning requirements. Any other questions on zoning and landmarks? Yes, ma'am.
Since you did 711, can you qualify 712?
Yes. So 712 is specifically for zoning lots that have an historic building, but is not entirely covered by a historic building. So 74-711 requires a preservation purpose. It requires a continuing maintenance plan. So yes, you can have flexibility on your enlargement or putting, say, the retail use on the ground floor, but you have to promise with a restrictive declaration that runs with that property forever that you will maintain that building in pristine Class A condition. The 74-712 does not have that bar. It's more about allowing flexibility for infill development within the historic district because, again, historic district boundaries do include those gas stations and do include those single-story buildings that were a garage or a manufacturing building that had zero architectural details, nothing special happened there. We need to have a little flexibility. Yes?
For the 779, who can buy the rights? Do they have to be adjacent?
So that's the flexibility. It does not require someone to be next door. It could be,
5 blocks away?
no, not that far. But we'll see what happens with East Midtown. Traditionally, it has meant that you can go across the street. So zoning lots are defined by streets. That's one of the ways you can define a zoning lot. So this is a mechanism to allow you to cross the street. So you can do, so say you have a corner landmark, you can go, and it's on the, I want to say on the northwest corner. You can go to the northeast corner, you can go to the southeast corner, and you can go to the southwest corner. You can go to the lot behind you and over one. Your boundary lines don't need to touch, but there needs to be that diagonal. There need what we refer to as nexus. They need to be close enough that you can justify the preservation purpose and the burden of the extra floor area on an additional site.
So to break it down, I'm sorry.
No, this is one of the complicated pieces.
Yeah, does it
Sure.
actually mean, say for instance, Grand Central, it means they would have to, the way that it works, they would have to be building a new building themselves across the street and using extra, or could they sell them, or how does?
So Grand Central has actually already sold their development rights. They sold them ages ago to preserve their building. A different company owns them and is looking to resell them. So who can buy them? Anyone who's looking to do a new building, but also anyone who has an existing building that has not yet maxed out its floor area or its zoning height.
And
or they could go through this special permit.
So anyone who, because it is transferable and sellable.
Yes.
Anyone who buys that can put extra floors on, basically.
Extra
They're buying
floors,
extra floor space.
right, extra floor
Within the
area
zoning.
within the zoning unless they go through this special permit. Okay, Lou, you had a question?
You can cross a street, a wide street, in the special permit process?
Yes.
So, okay.
Yeah.
Is there, is there any limitation on that other than just crossing a wide street?
You can cross the street. It's about the lot configuration. So you can go corner to corner, you can go across the street, but you can't go across the street and 3 blocks in.
I can't go.
Across the street and 3 blocks in. So you can't go to a mid-block site on the next block.
In other words,
You can go to other corners.
In other words, I could go straight across 13th Avenue or something like that.
Yes. Yeah.
So if you're in the Midtown Theater District and you met the contiguity requirements, you could sell privately and build as of right without using 7479?
If you do a zoning lot merger, that's a private sale. It doesn't require, a zoning lot merger is distribution of floor area versus a transfer of development rights. And if anyone else wants to know what all of that means, please come to advanced zoning.
Are the transfer or is the sale rather of development rights publicly reported information?
Yes, and we go into that in great detail in advanced zoning, but
Like an APRIS?
yes, yes. And that is literally, as Lou very well knows, is a whole 15-minute discussion just on all the different ways in which you have to track that. Okay, any other questions on zoning and landmarks? All right, so we're gonna launch into the last 50 years. So again, the landmarks law gave LPC the power to designate, but did not designate how they should do that. It did not give them rules. It said, you as an agency, figure it out, create your own rules, and that's what they have done over time. So I'm finally getting, I hope, to the section that will answer a number of questions that have come up during this training today, where how do we end up as a landmark? So the landmark process is a multi-step process, and it can begin with you. It can begin with the agency. And step 1 is identify a potential landmark or a district. So anyone can do this. It does not require owner permission. It does not require owner knowledge. Anyone can say, I think that building is worthy, but you have to say why. So Community Board 10 actually did their own comprehensive historic preservation plan using their urban fellow back in, I want to say it was, 2012. with conjunction with the committee chairs, and they identified a number of areas within their community board they thought were eligible and worthy of historic preservation. They submitted this plan to the LPC, and there it has stayed. We did not get past step 1 for most of the areas identified in CB10. That's not to say we don't want to. We certainly want to. But again, it's not enough to just identify the potential landmark or district. We have to get to step 2. We have to submit the request for evaluation. The request for evaluation requires nominal information. It says, please list the properties. Please say why you think they're important. They give you about a line to do so. Please provide your contact information. Optional information includes photographs, documentation, et al. The more robust this submission is, the better chance you have to move on to step 3. Now, this is the difference between the city process and the state and national process. The state and national process requires significant work up front. But once you do that work, you have a very good chance of going through the process. But again, it requires owner permission. The city process does not. So you want to have something become a landmark. You need to submit this request for evaluation. Our office can do it. The community board can do it. An individual member can submit the request for evaluation. There is no bar of entry. It is a public document. It's available off the LPC. It's a download PDF. You can handwrite it in. You can type it in. There's no requirement for blue or black pen. This is not meant as the end-all be-all stop for this process. It's a way to start the discussion going and to begin it. Now, if a community board wishes to submit an RFE, we highly, highly recommend you let us know so that we can follow it through the steps and make sure you're responded to.
So it means they might not respond.
We'll get to that. Things are better now. But we're talking, it took us a while to get to this. We're talking about 50 years of this agency work coming up with a process. Getting that process posted on the website. All right, step 3, research, analysis, and determination. This is done by LPC staff. Now, whereas the LPC commissioners are not required to have a historic preservation degree, they're not even really required based on some of their decisions in the past to like old buildings. LPC staff, it's a civil service title. You are required to have a degree in historic preservation to be a preservation analysis for the LPC. So the people who are actually doing the work of the agency in terms of analyzing the permits, looking at these RFEs, those are trained professionals. And we would encourage folks to give them their due deference. It's not easy doing deed research in New York City. It's not easy going to a property owner, because this is New York City, and saying, we're interested in researching your property and we think it has historic and aesthetic merit. Please let us in. But this is what the staff does. And the staff will make a determination. Is this property eligible and worthy for consideration by the public? So then the item will get calendared. It is only once the item is calendared and there's a noticing requirement that goes on the city record. How many folks have read the city record? Oh, more than last time. Okay, great. Not a popular newspaper for people to hear about these. Again, the notice is also posted on the LPC website. Typically, they let the local elected officials know and the community board. So look out for these notices. But again, nominal or minimum amount of noticing requirement. The LPC takes a vote and says, yes, we're going to put this on the calendar to consider it. It is not a decision. It just says, let's keep that discussion going on whether this property is significant enough to the history of New York City. Then we get to the public hearing. The public hearing is the opportunity for the public to weigh in on the criteria for designation. Why is this property or collection of buildings significant to their neighborhood's development? Why is it significant to the people who have lived there, or to the people who lived there 20 years ago, or 50 years ago, or 100 years ago? What other architectural significant details did staff miss because the property owners didn't let them onto the building, or couldn't see the backyard because of an existing structure? But you know there's something back there. This is the opportunity, and probably the most important opportunity the community will have to weigh in to move a designation forward. Historically, there has been no requirement for a time frame between the submission of your RFE, how long research takes, how long it takes to calendaring, and how long between calendaring and the public hearing. Then the LPC will vote. They may vote to designate. Then it will become a New York City landmark, and all regulations will apply effective immediately from that vote. LPC can also decline to vote. They can say, please remove from the calendar without prejudice. So say they feel there's still not sufficient information, or, as historically has happened, too much political pressure to not designate. Looking at you, Staten Island. See, there we go, 2 Staten Island references today. Or they can say, we choose to not designate based on merit. Based on all the information presented to them, they, the commissioners, feel that it is not worthy of New York City landmark designation. This does not bar something from coming back in the future if new information can be found. But this is considered final agency determination going back to that RFE. After the LPC votes, they have 10 days to submit to the City Planning Commission a report saying this is why we have designated it. The City Planning Commission then has 60 days to hold a hearing and decide whether the designation impacts any existing or pending land use or development proposals or plans, whether it is consistent with zoning, and whether it is appropriate to the neighborhood. There is no finding for the CPC based on economic development or impact. That is irrelevant. What is relevant, and what the City Planning Commission, sorry, using too many acronyms there, the City Planning Commission has consistently said is historic designation is absolutely consistent with, again, this idea of the police power of the zoning resolution. Preservation is a public purpose. It serves the general health, safety, and welfare of the population of New York City and is consistent with zoning. After the City Planning Commission votes, the City Council has a chance to weigh in. The City Council review starts 120 days with the LPC vote and the filing at City Planning Commission. The City Council has the ability to modify the proposal. This is important when we talk about historic district boundaries. They can remove portions. They cannot add because there's no documentation to support it. They can only make it smaller. They can choose to decline it. They can vote down the designation, or they can take a symbolic vote. They do not actually need to vote yes. The law does not require them to do so. But typically they symbolically say, yes, we're in favor of this. But that's important to note. They can do nothing and it will still be a landmark. So again, within Manhattan, we have a lot of historic districts. Between our historic districts and individual landmarks and our scenic landmarks, everything that is under LPC jurisdiction covers about 28% of the borough of Manhattan. We are doing very well preservation-wise compared to the other boroughs. Rebney might have a different opinion, but we think we're doing well. At the same time that our districts have been multiplying and our individual landmarks have been multiplying, that means more folks have to go into the LPC to request changes. So when we talk about the work of the LPC and permit applications, there's 3 different main types you'll need to think about. You have permits for minor work. So that could be something as simple as, I need to change out my toilet. I still need to go to LPC to make sure that by changing out my toilet, I don't accidentally take out the exterior wall. Staff review. You also need to go to the Department of Buildings. Remember, in all of this, you still need to go to the Department of Buildings. I don't want anyone to think they don't have to go there. A second type of permit is the certificate of no effect. So this typically encompasses, I want to say, the next level of work. So going back to what's in the charter and the rules of the agency in terms of what they're reviewing. So this can count as something like the removal of interior partition walls. Depending on what you're doing in the rear yard, if you're painting, for example, and it's a historic district that was very specific to paint color, that can be a permit of minor work. That does not get referred to the committee board. Again, staff level decisions. Bless you. The third piece and this only represents about 10% of the permits that actually goes through the LPC, is certificates of appropriateness. This is more significant work. This is an LPC commission vote. There is a ask that it goes to the community board for community board review. There is the requirement for a public hearing. Certificates of appropriateness, or C of A, includes enlargements, extensions. So enlargements is going vertical, extensions going horizontal. It includes window plans. I'm going to change out all of my windows. That window plan must include how many panes of windows each will have, and if I'm changing the fenestration pattern. If you're changing your door shape, and say you're a storefront facade, that is a certificate of appropriateness. You're changing the signs, certificate of appropriateness. If you're changing the color of the sign, permit for minor work or certificate of no effect, depending on the staff level decision and the size. So while the number of, I want to say, tax lots covered by LPC has grown, that means the work has also grown. And you can see just within fiscal year 2010 to fiscal 2014, we're not talking about a little increase. We're not talking about like a dozen or so more. We're talking about hundreds more within just a few years. At the same time, LPC has a much higher standard for what they will consider as an individual landmark in a historic district. If you look at the older designation reports, it is 10 font on a single page, single spaced, and that is it. Today's designation reports, for historic districts especially, can run in the hundreds of pages, still single spaced. There's a lot more work and research that goes into these designations now. So while the number of designations have dropped, the total volume of work the LPC has increased. And that's an important fact to remember when we look at how do we end up where we've ended up with the backlog or other situations or other problems we've been having in the last decade or so with the agency. Which brings us to Rizzoli. This was not a landmark. The community board thought it should be and submitted requests for evaluation for both the inside and outside 7 years ago now, and did not hear a response from the agency until they read in a newspaper that the LPC spokesman said, no, this is not worthy of designation. And when the community board found the demolition permits had been filed and granted at the Department of Buildings, that is when they learned of the agency decision for that particular request for evaluation. That is unacceptable. So this office, we submitted our own RFEs to force the agency to finally write a letter. We too received our letter, finally, a day after the newspaper article came out with the LPC spokesperson again saying, there is no new information for us to consider here. Double unacceptable. So what are the lessons we've learned from this? From this, just one example of what we are sure are dozens. There are no requirements for the agency to respond in writing to us or anyone else. It is very easy to fill out an RFE. So from a staff level perspective, I also have a degree in historic preservation. If I'm receiving 100 RFEs, and we actually don't know how many they receive because that's not tracked either, and they're from someone off the street, I don't know. Why should I look at that one? Why should I look at any of these? Because there's no documentation. It's a single sheet of paper, whether it's a historic district, an individual landmark, or a scenic landmark. So there's multiple parties to blame. How did we get here? The landmarks law does not require these timelines. The landmarks law does not require time frames. The rules of the agency do not require the level of responsiveness that we have gotten used to from other agencies, or we have gotten used to from other entities, from our government. That is a problem. If preservation is a public good, then all aspects of that work need to reflect that loftier purpose. So that is what we took away from Rizzoli. Yes?
What happened if somebody filed a FOIL request with LPC?
That is one way you can find out what the RFEs are.
Did anybody?
Yes.
Does it work? Do they actually respond?
FOIL responses can be done within 40 days, or the agency can request additional time. we do not get our responses until after the building permits were granted to demolish these buildings. So again, there's multiple regulations here. As a government official, we did not get a response. The community board did not get a response. So after Rizzoli, we all put our heads together with the landmarks groups and said, okay, are we the only ones not getting responded to? Who else is not getting responded to? This is a problem. If this was actually not worthy of designation, the community board should have been notified 7 years ago, 5 years ago, not 7 years after the fact. Then that brought us to the backlog. So following on the heels of Rizzoli, it was a fun first 6 months for us. Following on the heels of Rizzoli, November 2014 already, November 2014, we're getting ready to celebrate Thanksgiving. We've, filed all these ULURP recommendations. We think we can relax. And we see the LPC has posted an administrative action to remove 95 sites from the calendar. These sites have been on the calendar for 5 or more years. Some of them have been on the calendar for 20 plus years. What? So what did we do? So we can't speak for the other borough presidents or the other elected officials, but this office went out and visited all 35 sites in the borough of Manhattan that weekend. And what did we see? We saw what we felt were pretty obvious landmarks. Now, some of those items had been put on the calendar 6 years ago. IRT Powerhouse at 57th Street was put on when Gail was a council member. It was something she had requested. So here in administrative action, they were just going to knock all of this off and say, sorry, the work of the last 30 years doesn't matter. Our bad, we didn't get to it in a timely manner. We have the right to start fresh because we have all these other permits to do and we have the new administration priorities. So in fairness to the LPC, they do have a lot of work. And they were looking for an efficient way to deal with a problem they did not create, right? This was a 30-year in the making problem. So we told them, we understand the need to balance your current agency work, but we have a better way to do this. Do not do an administrative action. Take the time to talk to people. Have a public process. Post your research files online. Hold hearings on these items again. Some of these items haven't had hearings in 20 years. There has to be new information. Maybe the agency didn't move on an item because they didn't have enough information, but they thought architecturally it's probably going to be a landmark. Maybe the council member at the time said they wouldn't support it. Maybe the property owner said they wouldn't support it, and because it was in the earlier stages of the law, they weren't ready to test that piece. Whatever the reason was, here we are with 95 sites. The agency has the right to make their own work program, but the communities have the right to have their items heard. A lot of these actually never had hearings, or they couldn't find records of hearings because it had been that long. So thanks to Gail, we got our hearings. We got our process. All Manhattan items were heard. Out of the Manhattan items, which I'll get to the list in a moment, half of them are moving forward with designation. And the other ones were removed without prejudice from the calendar. We're the only borough to have items removed without prejudice. So there is still hope for those other items if new information or additional information can be found. But again, agency had the right to balance their work program. But we did not think it was fair or just to remove all those decades of work from preservation advocates and neighborhood advocates when to us, when we were out there, we're like, these are obvious landmarks. We just have to look at them. So, what are we left monitoring now for the backlog? We have these 12 sites. What was interesting was originally staff had only recommended 11. And in a testament to the importance of public discussion, because of the testimony heard during this meeting, the commission said, let's look at this list. We want to add one more. And they added the power company building on Gold Street in Community District 1. So this gives me hope and optimism that the LPC, that the commissioners, even though they are not required to level buildings, the process worked. They heard what people had to say. They were able to see the research for themselves. The community was able to see the research for themselves. And it was very hard then to justify why some of these were not moved, why some of them were going to be removed from the calendar. And it was really time to move forward with these sites. So as community board members, again, the process isn't done. These are on the calendar. They have been voted to designate, or they're prioritized, but the LPC votes have not occurred yet. And it's going to be happening in waves. So our office will continue to monitor, but the next steps are going to be the public hearings at the City Planning Commission to weigh whether these have an impact, an adverse impact to zoning or not. And then they go to the council. Not everyone at the City Council loves landmarks. If you as a community love any of these, please weigh in at the City Planning Commission when the hearing is held for your items in your community board, and please weigh in when the hearings are held at the City Council. Because the process is not done yet. Yes.
How are we notified?
Right. Community board members, please, please, please tell your district managers when they receive the designation report. It's a hard copy, it's hard to ignore. Comes with a nice notice letter and a receipt saying, yes, I've received this. Please inform them that it is their job, and they work for you guys. It is their job to tell the community board members that I have received this, it is moving forward in the process. That is how you will know. We're also going to try very hard to stay on top of the agendas and to get those messages out to the landmarks chairs, especially for the community boards. But again, we don't want to blast everyone every time. But if we hear that this is something you want to be made aware of on a regular basis, we're certainly happy to add you to the list for that. Yes.
So these 12 sites, these are now just going to LPC for vote?
They will go to LPC for a vote and the issuing of the designation report. Then next stop for them is the City Planning Commission for their hearing and vote on the appropriateness and whether it's complementary to zoning and development plans, and then it goes to City Council.
So step one so far is we've gotten some of these items off the backlog onto this list.
Yes.
All right.
Yes. Yes.
So if the LPC was to vote for a landmark site, City Planning Commission, if they voted no, what does that do?
City Council still has the right to take it up.
Okay.
And the mayor can also veto the decision. Yes.
In this complex and layered process, understandably, where does your influence or impact with the building department come up? I'm recalling, this was some years back, and I believe it was the Bonwit Teller building that was purchased by Donald Trump. And it was architecturally really had some lovely Art Deco pieces to it. And the Metropolitan Museum of Art, I believe, had agreed that if you would just remove them carefully, the museum would take possession. And instead, one day the workers just appeared, tore the whole thing down. So at what point does your office have or do not have the ability to say to the buildings department, don't issue that permit? Hold on, we have a discussion here.
Right. So for many years, there was no agreement between DOB and LPC on what to do when something was being considered. Today, there is a gentleman's agreement. It dates back to an internal policy memo. It is literally a handshake deal that DOB will tell LPC when someone issues a building, or I should say files or requests a building permit, whether to demolish, change, alter, start from scratch, for a building currently under consideration, whether it's part of the historic district or under individual landmark consideration. LPC then has 40 days under this gentleman's agreement to opine on whether they think it's okay or not okay for those changes to take place. And then DOB must make a decision. This requires a couple of other pieces in play. It requires DOB to enforce the wait period, right? If someone wants to go ahead in the middle of the night, and this happened actually on a number of buildings in the Jackson Heights Historic District, when that district was under consideration, a number of property owners did not want those apartment buildings designated. They went out there in the middle of the night with their crowbars and chipped off the terracotta tiles. So this is not, sadly, not unique to Manhattan. historically. Now, again, demolition by neglect loophole is closed. DOB has this gentleman's agreement with LPC. We certainly would like to see that formalized and have an official hold, but it requires vigilance. It requires, again, the community keeping their eyes on what's going on and having the ability to call the right people. Now, Gail has no problem calling the Department of Buildings Commissioner and screaming at him over the phone if something is happening. And I'm sure most of you already have her cell phone number, but we need to get the call. Again, even though Gail goes to so many events and is all throughout the borough, we may not be on that corner at that moment. So again, we really look to our community boards and our community board members to be our eyes on the street, to both identify what is worthy of designation, and we can help with that process. Again, it's a lot of steps. And to help with the enforcement.
So someone mentioned Lennox Lounge earlier. Just to bring this up, you mentioned earlier that we need the owner's approval. So no?
Not for
To
city.
file?
Not for city designation, no. Correct. You don't need owner's
State and
Where
national.
only for state
there
and
wasn't
national.
an owner of Lennox Lounge. There was like, they were renting the space.
Yeah.
Right, but that doesn't,
Yeah.
for a city, it doesn't have to be.
Yeah.
It could, anyone could
Right,
have.
and so going back to the
put in
Linux
a
Lounge
request.
example, are your questions now answered in terms of like the process? And yes, you could have submitted a request for evaluation, the lounge owner could have submitted a request, the owner, community board.
Well, it's in Community Board 10, it might have been in that package that.
No, it's, I believe it is part of that document, but again, the next they identified, you have to submit the paperwork.
I thought you said that, excuse me, I thought you had said to him that there was some sort of weight or something that if it had been filed, that they can't just, is that the gentleman's agreement you're talking about?
So if you submit a request for evaluation and you just submit that single sheet, that means the LPC staff has a lot of work to do if they think what you've identified is a good idea. If you submit it with a significant amount of documentation, that starts the ball rolling, but it doesn't ensure that it will. Now, in terms of once something is on the calendar, that is the only time that gentleman's agreement goes into play, because that is the only time something is now officially under consideration. LPC took a public vote to say, we are going to look at this. And that's where the regulatory framework comes in terms of, okay, we don't want something demolished while we're considering it for landmark designation. Before that point, someone may not even know their building is being evaluated.
So how do we fix this? How do we fix the law? I mean, is it law or is it just procedure or whatever? It's just because the way that it's going is crazy.
Yes, you had a question.
Yes, let's say the city council is voting on number 1, 315 Broadway. Do the city council members defer to the city council person for that district?
Traditionally, yes. Traditionally, yes. Yeah.
If the Landmarks Preservation Commission tells the DOB, looks great, it's a historic district, but this is great, it's okay, do it. That's a certificate of appropriateness or a permit?
At that stage, it's still the property is under consideration. So the LPC does not have the power to grant a permit. The Department of Buildings.
No, I know that. I'm asking, what is the LPC terminology?
There is no LPC terminology. The LPC has a courtesy review. They do not send over an official document.
The procedure you're talking about talks about approvals, so there's no document that approves it.
They can write a letter, they can send an email, they can make a phone call. There's no requirement for how that approval is communicated. Again, it's a gentleman's agreement.
No, I have it. It's 1988. I have it right here.
Yeah. So.
Not dealing with gentlemen.
Okay, yes.
Right.
Back to the RFE. So it behooves us to submit additional documentation with the RFE. Does it also work to have support from various groups when you submit it
Yes.
to, what is, I guess my question is, what makes the strongest RFE to just get it to the next step?
Okay, the strongest RFE will have like photographic documentation, statement of significance, description of the architects who have built the individual buildings, a list of significant residents for those individual buildings, if you're talking about a historic district, if you're talking about an individual landmark, as complete chain of title as you can get from ACRIS and the municipal archives, documentation on the original construction methodology. In terms of support, the community board support is incredibly important when we start talking about whether it's your borough president or the local council member. You want to build support. A number of community boards have their own criteria for what support means from them. A number of the community boards require, if you're talking about a district and there is a bid, that you have bid support, that you've gotten owner buy-in from a significant chunk of the owners within that district. The community boards themselves will hold a hearing before they issue a resolution in favor of the request. So there's a lot of different ways you can tease that out and pull that document together. From a technical standpoint, I would recommend that you follow the Historic American Building Survey requirements or criteria. It's available through the National Park Service. It really goes into detail in terms of when you're doing photo documentation of a building, what does that look like? What are the appropriate angles? How many pictures do you need? How many, here's the terminology when you're talking about it, or refer to fenestration pattern. That's literally for the windows of an individual brownstone, is it 3/3, as in 1, 2, 3 windows, or another 3 buildings? Like it gives you that terminology.
That's Historic American
Building Survey. Yeah, so that methodology, some of the HABS hair method. So it's Historic American Building Survey and Historic American Engineering Survey. So that framework gives you, I want to say, the tools and the terminology to speak to the LPC staff. Remember, these are trained experts in the field of preservation. They're more likely to understand what you are giving them if it is in their language. Yes.
All right, let's say that something is approved as a landmark and years later it's deemed that this community or a specific person doesn't think it should have landmark status. Is there a process to remove it from landmark status, and how is that carried out?
Technically, there is a process to do that. No one has exercised it. It would require a significant amount of public hearings and public process. The commission has never exercised that power as far as I know. I don't want to say never ever, but it is not something they've engaged in.
What about Mount Naboa?
Mountain what?
Mount Naboa on 79th Street. I think it was decertified.
Yeah, it was decalendared due to economic hardship, and I forget what the other criteria was, but it was like, again, it's not, I'm not saying it's impossible. There is a legal framework for it to happen, but it's very rare.
How about like on I don't know if this is familiar, but recently on 26th Street or 25th Street, that old beautiful church burned. Well, it didn't burn down, but the whole thing basically. Does, just, I guess, talk about that, I don't know, is it like destroyed or is there a process?
If they chose to rebuild, they would be permitted to do so. If they wanted to, I guess, go through this decommissioning process, they would have the ability to do so, because again, it was factors outside their control.
So otherwise they'll just leave it there burnt out, like the building in Berlin that got burned?
They could. I mean, I don't think as an active congregation they want to leave it as is. I would think they'd either choose to rebuild it as it was, or would pursue other development options. But that is, again, it is their property. They will require permission either way from various agencies, but at the end of the day, they will need to make a decision. Any other questions? So that was the last 51 years. So next 50. So again, because it's the Manhattan Borough President's Office Leadership Training, we want to leave you with what Gail's agenda is for landmarks. Things are not perfect. We're not doing badly. We have a lot to celebrate in terms of how many historic districts we have, how many individual landmarks we have. Again, we have over half of the scenic landmarks. We have a number of interior landmarks. We have done well for Manhattan, but there's more work to be done. Stonewall Inn represents the first time we have a culturally significant landmark. It is not the most aesthetically wonderful building, but it is certainly culturally significant and under the LPC power to designate. We want to see more. We have a lot of milestones in our shared cultural history that have not been recognized historically by the LPC. Designation and enforcement. Again, certain neighborhoods, certain community boards are more than covered than 28%. Again, the borough number. Some community boards are 50% covered by districts or landmarks, and other neighborhoods have been neglected. We want designation enforcement to be about consistency, transparency, and clarity. If the community board says we think our neighborhood is worthy, the LPC should listen. And we all should work together to do the research and documentation necessary so that something can be brought to designation and consideration. Landmarks should consider the value of all cultures and perspectives. We are a multifaceted borough and city. Our landmarks need to reflect that. Our office has actively been exploring legislative solutions that balance the value of preservation with the needs of the property owners. Now, what does that mean? Right now, as in next week, on the 7th, council members Greenfield and Koo are reintroducing their Intro 775, which will institute timelines for the LPC to consider individual landmarks in historic districts. There's a bud. We like timelines. Timelines help with consistency and clarity. For neighborhoods that do not have built-in advocacy groups, it will ensure that they have a fair chance at consideration and designation. But 20% of the districts LPC has considered over their entire history, their 51 history, has not met the 2-year time frame that this bill proposes. The original bill, as it was heard in September, instituted a moratorium. So if not enough research was done, which was more likely to happen in neighborhoods without those advocacy groups, they would get kicked off for 5 years without due consideration. So again, thanks to Gail, thanks to the landmarks groups, and thanks to a number of our community boards who came out at the hearings for this, the moratorium is off. They are moving forward with the timeline piece. We would continue to ask people to think about, timelines are a good thing, are we putting in the right timeframes? We think at least another year for historic districts would be better, so it would be 1 year for individual landmarks and 3 years for historic districts. But this is moving forward without a moratorium. What else needs to change? We need to look at how RFEs, or requests for evaluations, are evaluated and responded to. Again, if staff makes the determination that it's not worthy of further work, they need to tell someone other than themselves. Because we don't want community boards who have, or volunteers, and have limited resources to spend time on something that an agency has said, we don't think there's enough here. Especially when a number of our community boards have a relatively long list of what they think is worthy. We want all of our attention and resources spent together on those that we think will be most successful. It also means we need to know what's already been submitted. We don't know what the universe of requests for evaluations are. We have no idea. We want a database. We want to know what's already been opined on. We want to have a central database that tracks all the LPC reports and all of the permits that have been issued, so that once something has been designated, once a neighborhood has worked really hard to have something designated, they can track what permits are issued for that building. All the other city agencies have their permits online. LPC should too. What else does this mean? We don't want a handshake. We don't want a woman laughed. We don't want a memo. that lives at DOB on their website, buried as a number that doesn't even say LPC in the title. We want it part of the landmarks law that there's an official hold. So you're gonna, over the next few months, we see that the city council is moving forward on a number of these things. Again, not every city council member who is gonna be putting forth legislation, not even the central office necessarily has preservation as their number one priority. Gail does. So we're gonna be looking very closely at these bills, bless you, and would encourage our community boards to look closely as well, and to look at your own community board history when it comes to designation, whether it's districts or landmarks. One size does not fit all for a lot of these things, but we do need predictability. So we would say over and over again, we support predictability. We just want to make sure it's fair. So that's where we're going to end today with where we'd like to see the landmarks law going in the next 50 years. And any other outstanding questions?
When last time the 775 was up, a lot of the testimony focused on differentiating between applications, RFPs that were supported by either board or
You haven't signed in, can you please sign in?
and they would be treated differently. Is that
Yes. Yeah, so I think we'll, again, haven't seen final full language, but that's where we'll.
Haven't signed in, please sign in.
Just a agency, the only agency that actually testified
Yeah, it was the one that was updated
Like they had, the council has 100.
And then I was curious about it myself, because I'm the church that heard that. I gotta take the notes on. I always feel like this.
Yeah, no, I said that as the council 120 starts when.
Yeah, I haven't seen anything presented. What they wanted to do and what a rebuild is.
I'm not gonna have a
How have you been? How's everything? Good to see you. That too. And my mom's funeral was Thursday. I just think there's something Thursday. Yeah. So try to get my energy back up. I definitely needed to get out of the house. So I'm glad that things can start now. I missed everything that was last week. So I missed the 101 that she's talking about. So see if I can get that that training on these materials. Alright, thank you. Yeah. Thanks.
Projects.
They're hanging in there, you know. I have so many teenagers and young adults graduating from college this year. Family, it's like, gotta keep my head up to keep their heads up. You know.
But the thing is,
It's been that long that your boys have finished. They're finished, yeah. And I'm on college tours. I want to say maybe 2 or 3 times a month with Jonathan. And when I was there, yeah, she was in elementary school when I was at CEC, so.
What are your boys doing?
This is an electrical engineer to the first grade. I don't know, I don't remember the name, but the marketing company that Demetrius with his Angel's marketing with a minor in business and finance.
So here's another way to look at it.
Yeah, so they came right out of college and right into their field, which is great. So Hofstra did a good job. Hofstra produced marketable, employable adults, which is wonderful. I'm very proud of them. I told Hofstra, you know, if you need anything from us, speeches at the school or anything, I told the boys to make sure you volunteer because it's very rare.
And
They took college jobs 30 days out of school. 30 days. And Dimitri, about 2 months.